Hey guys, sorry, it's a little last minute. I was actually expecting none of this to come out until after the hearing came up or the hearing at 5 p.m. today, which we're supposed to dial into, which she'll probably try to appeal. So I'm guessing they'll talk about that during the hearing because the public can dial in, and that's in 30 minutes. But Justin Baldoni prevailed on every single count in this lawsuit after the motion for summary judgment and the motion for judgment on the pleading. Blake Lively's sexual harassment claims did not survive. Only 3 counts survived, and they are against other parties, including the agency group PR and It Ends With Us Movie LLC. None of her claims against Justin Baldoni or Jamie Heath survived. We'll go over this a little bit here. I'm not going to be able to read through it word for word, but this is pretty crazy. Let me wait a minute for people to get in here, just because I know this is kind of last second. So if you are watching this on replay, just wait until you see the document on the screen, or skip ahead until you see the document on the screen. So for right now, I'm going to pull this up, but I'm going to mute myself for a second while I let some more people come in, okay? All right, I think we're good. I got enough people in here. Let me pull up the ruling now. So this is the ruling on both the motion for judgment on the pleadings and the motion for summary judgment. Let me skip you down to the end here so we can kind of, get to the point. This is not going to be a super long stream. I'll be back with Omar tonight to talk about it more. Like I said, she'll probably try to appeal that, but we'll see how that goes. They'll probably talk about that tonight in half an hour at their hearing, which everybody can dial into. The information's on the docket. Let me make it a little easier to read. But here's what the order ultimately says. It says the motions for judgment on the pleadings and summary judgment are granted in part and denied in part. Judgment is granted in the Wayfarer party's favor with respect to all counts in the second amended complaint, except for 1, Lively's 4th cause of action for retaliation in violation of FEHA against It Ends With Us Movie and Wayfarer. You notice that not all the parties are involved in that, just those 2. 2, Lively's 7th cause of action against TAG for aiding and abetting retaliation in violation of FEHA. And 3, Lively's 9th cause of action for breach of the CRA against It Ends With Us Movie. So, sexual harassment claims are all gone. These parties and these 3 claims remain, but you'll notice Justin is not listed on any of these. So, not every single party is still attached to every single claim. I suppose these would still go forward on the 18th if she wants to, and I'm sure she will. But yeah. Okay. Give me 1 second. Let's move up to the top here, read a little bit. We won't read, like I said, we won't read the whole thing. It's 152 pages, which is just nutty. And I will want to listen to that hearing at 5. So what I'll do probably is come back and read more of it after that hearing. So let's see. Give me 1 second. I was not prepared for this. I really thought this was going to take longer. I didn't expect him to drop this right before that hearing. Give me just 1 second here. Terry says, I wonder how the retaliation stands if she wasn't an employee. Well, the thing is, the judge is probably saying that that's something that has to be determined by a jury, that there's still an issue that the jury will need to decide. It's not necessarily saying that that's definitely what happened, to my understanding. We'll have to ask one of the lawyers who's covering this case if that's, so. but my understanding is that these things would then proceed to trial. But don't quote me on that. Let's wait and see what like NAG or somebody says about it. So, okay. This lawsuit grows out of events occurring during the production and promotion of the Hollywood film It Ends With Us, and a very public fallout, that's an understatement, between its two co-stars, Blake Lively and Justin Baldoni. Baldoni and his co-defendants, the Wayfarer parties, now move for judgment in their favor on all claims. They bring two motions to do so, a motion for judgment on the pleadings and a motion for summary judgment. Sorry, I'm just like, this is wow, such a relief. I wish I had more time to gather myself before we get out here. For the following reasons, the motions are granted in part and denied in part. And like I just read to you guys, only those three claims against those parties survived. So, in particular, the motions are granted except with respect to Lively's fourth cause of action for retaliation against It Ends With Us movie and Wayfarer Studios, her seventh cause of action against TAG for aiding and abetting retaliation, and her ninth cause of action for breach of an agreement called the Contract Writer Agreement against It Ends With Us movie LLC. So what would happen here is they would then have to determine if TAG and It Ends With Us movie and Wayfarer Studios acted in retaliation for Lively reporting claims of sexual harassment. So the sexual harassment claim is gone. But the retaliatory act would be this accusation that they're defaming or smearing her, I guess, because she reported sexual harassment. And he's not saying that's what happened, but that is something that could move forward to trial. I think this would be oh my God, such a waste of her time, which is why I'm sure she'll do it. But, oh man. Then it really is such a relief, dude. These guys have been through so much, and she has put everyone through hell. And I do believe, what a lot of people were saying about Judge Liman. I know he's not a fan favorite for sure, but that he was giving her as much as possible to make this not an appealable issue. Damn. Okay. All right. So we have those causes. Let's see. The following facts are described in summary form at the outset, with a more detailed description of the evidence recited in the section to which it is relevant. The facts are undisputed for purposes of these motions, except where otherwise noted and construed in Lively's favor as the non-moving party. Okay. 1 second here. Okay. The film at the heart of the lawsuit is based on a successful novel by Colleen Hoover of the same title, and luckily I never had to read the book. I said I was going to, but if this doesn't go to trial, I don't have to read the book. I read an excerpt of the book, and I'm still trying to recover. It was the spoon licking scene, and okay. Anyways, I don't think we need to reread all this. We don't need to rehash all this. We all know what's going on here, right? Okay. Talks about the writer's strike, the stops, and how they came back. The 17-point list. I am going to do the best I can to get through some of the meat of this while skimming over, the other stuff in the little time that we have here. Okay. I promise the next stream I do will be better. It's just the last second thing. Oh my God, I was not expecting this. All right. Then he gets into the procedural history. I don't think we need to do that. They held the oral arguments on January 22nd, right? Okay. Okay. When we get into the legal standard, I'm not going to be the best person to read this word for word for you and tell you how the law works. So again, this is another thing that I'm going to kind of skim over for now. And then later when I come back with Omar, we'll talk about that. Okay. He does note here, summary judgment is appropriate where the movement shows that there is no genuine dispute as to any material fact. So the things that have not been, thrown out, there is probably a fact issue for the jury to determine. So that would be one reason why the retaliation thing would move forward, right? Where's Nag? Can Lauren have her jump on? She did offer to do this when the ruling came out, but I wanted to get to this right away. So I will be back later. Actually, I'll invite her to join me and Omar if she wants to tonight. If you guys want to remind me, because I would love to. She did offer, like I said, and I'd be happy to take her up on that. There's going to be a lot she can tell you that I cannot. So, all right. Let's see. All right. The movement bears the burden of demonstrating the absence of a genuine issue of material facts. Okay. We don't need to read that. You know, I'm going to just skip to the discussion. Yep. Okay. Lively brings 13 claims against the Wayfarer parties, and then he lists off all the claims. Of course, you guys know, number one, sexual harassment was thrown out completely. And then we just had those three that move forward. I'm not going to read them again right this second. Through their two pending motions, the Wayfarer parties move for judgment on all claims. Their motions for judgment on the pleadings and summary judgment overlap in many respects. To the extent they do not, however, the parties dispute whether the court should, in considering the motion for judgment on the pleadings, also consider factual disputes presented in the motion for summary judgment. Lively contends that even if the Wayfarer parties have identified some deficiency in her pleadings, the court should conform the pleadings to the evidence in the summary judgment record and evaluate the Wayfarer parties' arguments on that basis. Okay. He talks about that recent Second Circuit decision. We talked about that a couple of weeks ago. They had filed a letter with the judge talking about this supplemental authority because an appeals court ruled that the judge in this case, the Miller case, should have considered the evidence in a motion for summary judgment and decided not to, which I didn't really understand the relevance there. But I guess if the judge had decided to conform the pleadings motion to a summary judgment motion, then it'd be different. We won't get too deep into the weeds there right now. Let me see if he actually did that or not. Okay. All right, so I think he's still quoting that case here. Here, the parties have completed an extensive and fiercely contested discovery process. The Wayfarer party's motion for judgment on the pleadings came towards the end of that process, and only shortly before its motion for summary judgment. In these circumstances, it would hardly serve the efficient or just resolution of this dispute for the court to limit its analysis solely to the pleadings rather than the entire record on summary judgment. Okay, let me think about that. Okay. In any event, this dispute ultimately matters very little, as the Wayfarer parties have identified only a handful of allegations which they believe should be disregarded in consideration of the motion for judgment on the pleadings. And those allegations are immaterial to any determinations the court reaches. So I guess it didn't matter. Hold on, my dad is calling me. Give me 1 sec. I'll mute myself really quick, guys. All right, I think that was a butt dial. Let me just tell him to come in. Okay. Dad, not now. All right. Sorry about that. He's coming to get the dog. So, all right. Here, the parties have completed an extensive and fiercely contested discovery process. We went through that. Let's see, the court starts with Lively's contract claims and then proceeds to discuss her federal claims, her California statutory claims, and her common law claims. I don't have a lot of time, like I said, guys. So why don't I skip to some of this stuff? Like I said, I'll come back later and go through all of this. This is not going to be the best and most organized live stream I have ever done. I'm going to get to the interesting stuff. How about that? We'll just skip to the sexual harassment claims. So he's talking about the ALA here. The ALA is unenforceable. Huh. Because she didn't sign it. Oh, shit. I was wondering if that would matter or not. Okay, so... Oh, no. That's what they contended. I don't know if that's what he decided. Let's find out. She never would sign her fucking contract. Lively responds they're stopped from raising such an argument by their prior efforts to enforce the agreement that they have waived the conditions. Okay. You guys know I hate choice of law stuff. I'm not even going to fuck with that. She's using California law. Which defendants are now subject to her contract claim. Okay. Yeah, no, this is definitely something I need help with. I can't do this by myself. I'm going to skip to the sexual harassment section. Thank you, Sarah Jupiter James, for the 5. Never apologize. You're the best. We appreciate you. This is amazing news. Thanks for being on top of it as usual. Thank you very much. Love you too. I'll read the rest of these in a minute. I'm just trying to gather my thoughts at the moment. Okay. I'm trying to navigate up this 150-page document on like nothing. So just be patient with me. Okay. Lively brings sexual harassment claims against It Ends With Us movie, Wayfarer, Baldoni, and Heath under FEHA, and against Baldoni and Heath under California Civil Code Section 51.9, right? The crux of these claims is that the defendants harassed Lively and subjected her to a hostile work environment on the basis of her sex and or gender. Lively's allegations center largely around conduct which occurred on the set of the film during the first phase of production in New Jersey. This on-set conduct occurred outside California and cannot support applying the statutes extraterritorially. I fucking hate that word. If I never hear it again, it'll be too soon. One second. I think my dad's at the door. You can hear the dog there. I just got a text from Omar. It just says, holy shit. I know what this is about. My dad says hi. I'm muting myself until he leaves. Well, you can probably hear him downstairs, but it's okay. All right. But yeah, when I come back tonight, I'll have to invite everybody else if they want to hang out. Since I'm only doing this for a few more minutes, it's just me right now. Okay. Let's see. The crux of these claims is that the defendants harassed Lively and subjected her to a hostile work environment on the basis of her sex and or gender. Lively's allegations center largely around conduct which occurred on the set of the film during the first phase of production in New Jersey. This on-set conduct occurred outside California and cannot support applying the statutes extraterritorially. Let's see. Recognizing as much, Lively asserts the key decisions that enabled, escalated, and perpetuated the hostile work environment were made in California by executives supervising Ms. Lively's employment from Wayfarer's California headquarters. Specifically, she alleges that Baldoni and Heath made critical pre-production decisions from California that enabled harassment to occur and left cast and crew without protections once filming moved to New Jersey. Which is kind of funny when you consider Blake Lively deemed herself the head of HR. I mean, okay. All right. For that proposition, Lively asserts that Heath, acting from California, failed to hire a separate HR presence for production, even though Baldoni had a potential conflict of interest as the film's director and Wayfarer's chairman. Lively also points to Wayfair's failure to provide sexual harassment training to cast and crew after Sony informed it that Sony would not be responsible for the training. She asserts these California-based management decisions effectively guaranteed that once filming began, there would be no meaningful mechanism for Ms. Lively or any other cast member to report inappropriate behavior. Okay. Lively alleges that additional conduct in California set the tone for harassment. Shortly after she accepted the role, Heath sent the following text to Baldoni while Heath was in California. It says, "I'm at home with my daughter, husband, and wife with a visit from her midwife, going through the process for her home birth. It's very magical. This is all to say the energy of bringing life into the world is surrounding us. We are birthing Blake into this role." And she was actually like, "Give me millions of dollars." What a bitch. Anyways, Lively states that this comment sexualized her and invoked female reproductive imagery to describe her professional contributions, signaling that her value was tied to her gender rather than her talent. What talent? Anyways. Subpoena that, bitch. Anyways. Lively points also to the fact that during a pre-production Zoom meeting, Baldoni, presumably joining from California where he resided, lashed out at a female producer for disagreeing with him and subsequently sent an apology to that producer. What a fucking monster, right? Also presumably from California. Lively further states that when she and Slate complained to Giannetti about Baldoni and Heath's behavior, Giannetti, who was in California, failed to act because she did not believe Sony was responsible. Okay. When efforts were finally made to address Ms. Lively's complaints and complaints by other female personnel, they were done via negotiation between Sony, Wayfarer, and Ms. Lively's personal counsel in California. Lively contends that the harassment also continued after filming. In particular, she claims the Wayfarer parties planned, coordinated, and implemented a smear campaign from California, which was intended to cast her in a false light, discredit her claims, and damage her career. In addition, after Ms. Lively filed her CRD complaint in December 2024, another California-based act, defendants launched a second wave of retaliation, executed in part through their California-based attorney, Brian Friedman. Oh, Brian. Who made defamatory public statements and filed defendants' retaliatory counter lawsuit from California. Finally, Lively contends that her employment relationship was established through a contracting relationship between Wayfarer and Ends With Us Movie, Blakely Incorporated, all California entities negotiated in California through California-based representatives. In sum, she concludes that these facts show that the harassment on set was the foreseeable extension of a hostile environment conceived in California, directed by California executives, and perpetuated through California-based decisions, policies, and omissions. Okay. None of these acts or occurrences provides the substantial connection to California needed to sustain Lively's sexual harassment claims under FEHA in Section 51.9. Most notably, the acts do not implicate issues of core or ultimate wrongdoing having any bearing on the material elements of the cause of action. Okay. To start, many of the acts were not even taken by the Wayfarer parties and therefore do not involve conduct which gives rise to liability. The fact that non-party Giannetti, The fact that non-party Giannetti of Sony may have failed to act on complaints from Slate and Lively while in California cannot support a claim for harassment against the Wayfarer parties under California law. There is no evidence that Giannetti was acting on behalf of the Wayfarer parties or that she directed or ratified any discriminatory behavior. What are you going to do now? Sue Sony? Jesus. Furthermore, the fact that Lively's counsel and representatives negotiated her employment relationship while they were in California, or that Lively filed her CRD complaint in California, cannot support the application of California law. A plaintiff cannot transform an otherwise extraterritorial claim into a territorial claim by the unilateral decision to challenge the defendant's conduct in California. Okay. Nor do the Wayfarer party's own California-based acts establish the core of her claim arose from California. The vague assertion that Heath's private text message to Baldoni about the birth of his child set the tone for harassment implicitly concedes that the conduct Lively has identified does not itself go to the core of her complaints. No reasonable jury could conclude that Heath's text message about being at home with his family bore a sufficient relation to the sexual harassment Lively claims to have later occurred on set, or that Baldoni lashing out at a female producer in a Zoom meeting while in California has a substantial bearing on a material element of her claims. Lively's efforts to invoke retaliatory acts taken in California as a basis for sustaining her sexual harassment claims are without merit. She asserts that under California law, retaliatory acts can constitute continuing harassment of an employee, and that because the retaliatory smear campaign was implemented from California, that means her sexual harassment claims also involve California-based conduct. God, she's just gutted here. Wow. Okay. Let's see. The court will separately address issues of extraterritoriality as they relate to her retaliation claims. However, even if there might be some circumstances in which retaliatory acts exacerbate a hostile work environment and therefore qualify as a kind of continuing harassment, That is not the case here. The retaliatory smear campaign is alleged to have begun after Lively's working relationship with the Wayfarer parties concluded. The alleged act of retaliation therefore plainly cannot support a hostile work environment claim. Finally, failing to hire additional HR personnel or to share HR policies with cast and crew was not the core of the alleged wrongful conduct underlying Lively's sexual harassment claims. To the extent Lively suggests there might have been other California-based decisions, policies, and omissions responsible for her harassment, courts are clear that formulaic recitations regarding California decision makers who, whatever the fuck this means, instituted, approved, ratified, affirmed, and or implemented the discriminatory policies cannot provide a sufficient factual nexus. And I'm going to be honest with you, I have no idea what I just read. My mind is going 1,000 miles an hour. Wow. Okay. Okay, this hearing starts in 7 minutes. I'm not going to be able to get through much more of this. So what I'm going to do is I'm going to come back pretty soon. I'll, after the hearing ends, I'll schedule the live for, why don't I schedule it for like 8 p.m. Eastern? And then I might move it up. We'll see. I might move it up. But wow, this was, I was not expecting this. Look, man, I'll tell you what, without reading the rest of that, I can tell you there's going to be a lot of people who are not very happy with that. A lot of people who are not fans of mine, who are not going to be happy with my reaction to this. And to that I say, fuck you. Because you know what? This whole thing has been needlessly emotional and stressful for a lot of people. And these people did not deserve what Blake Lively put them through. I'm so sick of her nonsense. And honestly, I want this to be over. But even though he ruled against her, don't rule out an appeal. She might pull it. We'll see. But honestly, I think in her best interest would be to walk away now, not even proceed with the remaining claims to trial. But we'll see. We'll see. I would recommend anyone go listen to, I think, Nag or anybody else who's attorney-wise explaining this right now. Let me see if I can direct you guys to someone. But I don't know if anybody's doing it right now because we're waiting for the hearing. Which, if you missed the dial-in info, let me pull it up for you right now, actually. So here's the code and the phone number. I highlighted in red right there if you want to write it down, because that starts in 6 minutes and anybody can listen in. I will read the super chats if you stop yelling at me. Just give me 1 second to see if I can direct you guys to anybody after this. No, that's not what I'm trying to do. I did that. Yeah, why don't I send you to CJ? All right, but if you missed it, one more time, just in case you missed the beginning of this, we'll go back down to the bottom. There's only 3 remaining claims against certain parties. Right, it's the retaliation and violation of FEHA against It Ends With Us movie and Wayfarer, aiding and abetting retaliation against TAG, and then breach of the CRA against It Ends With Us movie. You'll notice none of those causes were made against Justin Baldoni, Jamie Heath, Steve Sarowitz, etc. So these claims are surviving. We'll see how that goes. I doubt she'll need those 1,000 exhibits she dropped on them in pretrial now, or the 40 trial witnesses she listed. Let's not needlessly drag anyone else in Hollywood through this, shall we? All right. I don't know how to pronounce this. Shion, thank you for the $10 super sticker. I hope I said that right. I'm really sorry if I didn't. Selma, thank you for the $2.79. Congrats to everyone. Wow, great day. Yeah, it's pretty crazy. Thank you again, Selma, for the $2.79, giving everyone a big hug and also a big group digital hug, everyone. Thank you. I appreciate that very much. Dima, thank you for the, I don't know what JOD stands for, but for the 70. Thank you so much for making our day, Lauren. You're the best. Love you. Thank you very much for being here. Appreciate that. Big Z, thank you for the 5. I know that you guys are like not a fan of these creators. I will say personally, I try not to throw mud too much. There have been a couple times when that guy has made some really interesting accusations against me. I don't know him. He's not part of my life. I have no idea why he would say the things that he said. But honestly, I don't really get involved in creator wars. I don't sling mud. I did meet MJ actually at the courthouse, and I think that we just have very different ways of thinking about this. We have very different opinions. I wish her well. I think she was really polite to me. I have no problem with her. I'll be honest. I know that a lot of people have strong opinions about different creators on both sides of this, but at the end of the day, I have no hate in my heart for those people. You know what I mean? Like, I'm not trying to steal your your happy feelings here, but I just want to put that out there. As long as I'm reading this comment, that for me personally, there's no hate here. So, no SH, as we knew all along. Her case is scuppered. Will she settle now? She's cooked. I have no idea. I think it would be in her best interest to settle. So I don't. No, she won't. Okay. Thank you again, Big Z, for the 5. Is Omar joining? Wondering if Ask Two lawyers are going to cover again. Can't wait to see the Vile meltdown. Fuck Nick Vile. I will say that. How about that? What's in New York Times going to say now? Bye, Blake. Yeah. Thank you again for the 5. I appreciate that. Omar will be here later. Not right now, though, because I got to join this hearing in 2 minutes, so I don't miss anything. Like I said, I'll schedule the next stream out till 8 o'clock. I'm going to send you over to CJ right now, and I'll talk to you guys soon. Thanks.